Supreme Court of India PM Lokanath and others versus State of Karnataka and others decided on 6 February 2025 Manu/SC/0200/2025 facts of the case, on November 25, 2008. Respondent number 2 however lodged an FIR under sections 448 and 506 of IPC alleging therein that the appellants had threatened respondent number 2 to withdraw the civil suits. In the said FIR, it was further alleged that respondent number 2 was threatened by the appellants that in case he does not withdraw the civil suits, he will meet with the dire consequence of his death. ACMM took cognizance and issued summons to the appellants herein. High Court, though noticed that there was a long-standing civil dispute between the parties, refused to quash the proceedings. Findings of the court. From the perusal of the record, it is clear that it is the appellants who have filed 2 civil suits, i.e. one for permanent injunction and the other for the declaration of the ownership of the suit property. In the suit for permanent injunction, an order under Order 39 Rules 1 and 2 of the Code of Civil Procedure has been passed by the principal city civil and sessions judge, thereby restraining respondent number 2 and his siblings from interfering with the physical possession of the appellants. It is thus clear that the allegations in the FIR are totally absurd. When respondent number 2 has not filed any suit, there is no question of appellants threatening him of dire consequences if he does not withdraw the suit. It further appears from the record that respondent number 2 is in the habit of filing false cases against the appellants and his family members. There are similar allegations that the appellants and his relatives were threatening respondent number 2. The learned ACMM, after considering the evidence placed on record, found that the allegations made by respondent number 2 were totally false and the appellants were, therefore, acquitted. We are, therefore, of the considered view that respondent number 2 and his relatives are in the habit of filing false and malicious cases against the appellants only on account of long-standing civil dispute pending between them. The initiation of criminal proceedings at the instance of respondent number 2 in the present case is totally activated by mala fide, instituted with an ulterior motive for wreaking vengeance and with a view to spite the appellants. We, therefore, find that the continuation of the criminal proceedings against the appellants would be nothing else but an abuse of the process of law. The appeal is, accordingly, allowed. The impugned judgment and order passed by the learned single judge of the High Court is quashed and set aside. The charge sheet registered before the court of issuing summons to the appellants and the subsequent proceedings arising therefrom are also quashed and set aside.